guys, it's Kathy. Happy New Year. I hope you guys started this new year off great. I have some good stuff today. um, and don't worry, I don't ever post horrible stuff here. So, one case may seem like it's horrible, just trust and relax. But let's start with let's just start with end of the year hilarious.
This is file 2302-124, the people of the city of Royal Oak versus Larry Gene Mason.
Magistrate, good morning. And for the record, my name is Patrick Gagnick. I'm here on behalf of Mr. Mason. Just a heads up, Mr. Mason's a little hard of hearing, so I'll try to keep my voice up as best I can. Mr. Mason, can you state your name?
State your name. State your name. State your name for the court.
What's it? You asking me?
Yes.
What's it want?
Your name. You need to state your name.
Larry Mason.
Mr. Mason, can you hear us? Can you hear me?
He's hard of hearing, Pat. I'm like right next to him. So
I get it. I just want to make sure he knows. Mr. Mason, can you hear us right now?
I can hear you occasionally. Yeah, I heard
Okay.
what you.
I'll speak slow and I'll speak
That's
short. But
good. Thank you.
we talked, Mr. Mason. We spoke in private just now, correct?
I tell you what.
that's the gentleman you were speaking with earlier.
I didn't understand what you said.
Okay, you were talking to him about the charges and how you wanted to represent yourself, and then so he was explaining the procedure of how today was going to go.
Okay, all right.
So with that said, magistrate, I did speak with him in private. He does acknowledge the charges. We were able to converse. Just asked that a not guilty plea be entered. He made a request he'd like to represent himself going forward.
There, right there.
Plea of not guilty does enter. Mr. Mason, can you hear me?
Yes, if I think so.
Mr. Mason, you need a lawyer.
Well, I'm an ex-lawyer because I'm retired and have been for 5 years or so.
But you still need a lawyer. Mr. Gagniak would be appointed to represent you.
Now I don't want a lawyer.
The only advice that I can ethically give you is the advice to be represented by counsel. You have a right to represent yourself. But if you were a lawyer, you would retain your own lawyer. A lawyer would not represent himself in court. But you have the right to represent yourself. You can also change your mind. And if you change your mind, just let the court know. You're going to get a letter that will tell you when the pretrial conference is going to be. It'll be mailed to your home, and you still live on Alicia Court.
Yes.
Mr. Mason, how did you get to court today?
I drove.
You got the new plates. Mr. Gagniak, ask the bond, please.
He did appear here timely this morning. I had asked him if anything like this has ever happened in the past, and he declined that. I'd ask you to consider a personal bond. I'd leave any other conditions certainly to your discretion.
The record should reflect that the Secretary of State's printout of his driving record shows the only thing on it are the issues that arose from this incident. No prior tickets whatsoever show on his record. He is here timely. Mr. Mason, does your family know you're here?
Well, they know I'm coming.
Okay, your
Get up
family
early.
does know you got the tickets.
That's what?
Does your family know that you got these tickets?
Oh, well, I guess they do. I mean, I haven't had a lot of conversation with anybody about this. So I have told my children and my wife's children some things. But they're all adults.
Okay, they're all adults, of course.
They're not around here. I mean, they don't live except for a couple of them. They live all over the country.
If you're going to choose not to retain a counsel or not to request appointed counsel, wouldn't be a bad idea to speak with family about how you want to handle this. You don't need to handle it alone. My first piece of advice would be to work with an attorney. But if that's not going to happen, check this out with your family. Bond is going to be $1,000 personal. You do not need to pay money to leave. It's a personal bond. We're taking it on your word. You're going to come back for the pretrial. And again, you'll be notified of the pretrial by mail. It'll be a Zoom hearing just like today. If you choose to come into the courthouse, that'll work too. And good luck to you. Thank you. You're all set today, sir.
Thank you.
That's going to be a great, great hearing. Okay, I have an update. I have an update on a case that we did in Colorado with Butler is the attorney, and the judge just losing all control of the court. Let's move on to the update.
So I don't know if I give this to you.
No, I don't have anything. We just ended up talking to somebody on the application here. So let me see if I can get this set up. I forgot we should have a stand. Let me see if I can get it set up in a way that's conducive for you.
Okay.
Yeah, maybe not.
Actually, you can run my plate.
Oh, that
Ms.
could work.
Butler,
Yeah.
would you need to talk to Veronica in the breakout room first?
Tonight or something?
Yes, I do.
Okay. Officer,
Thank you so much.
Officer, I'm gonna send another invitation for you to join get Miss Molina to join Miss Butler in the breakout room.
I'm sorry, it's one of these.
We are ready for the breakout room when you guys are.
Can you see me okay?
Veronica, I'm gonna head over and meet you in the breakout room.
Miss Butler looks like they have joined the breakout room.
Okay. I just before I went over and met her, I just wanted to give everyone a quick update. After, I was really encouraged. I think everyone was after the last time we saw Veronica in court. Elodie and I met with her yesterday at the jail. Elodie brought the forms. Unfortunately, it was not as successful as I was hoping. Veronica wasn't nearly as, clear-headed or open as she was when she appeared in court. So we left the paper with her, and I kind of talked to her about what the options were today. I'll meet with her right now and I'll talk to her about that, but I just wanted to let everybody know kind of how that meeting went.
Thank you.
Yeah.
Just as a heads up, Veronica, leave the iPad here in the chair from now on,
No,
okay?
it isn't.
So I can't have you walking around.
Judge.
Okay.
Judge.
Your Honor, we're back on the record.
Okay. We are back on the record. We have Ms. Torres
Yo,
here.
Can you hear me?
I can.
Hi, nice haircut.
Well, thank you.
You're welcome. So, Judge, I signed your paper.
Let me just talk to Ms. Butler too. So let her jump in, but I'm happy to hear wherever we're at. So Ms. Butler, if you can just share us where we're at.
Thank you, Your Honor. So I met with Ms. Torres Villalobos, and Veronica, is that still how you'd like to be referred to, Ms. Torres Villalobos?
I can't remember this. That's all the way up. I'll just go in my room.
Yeah, that's fine, I guess.
Damn chicks. These chicks won't shut up and they're so goddamn loud. I don't have any fucking respect. Yo, can you hear me?
We can hear you.
Can you hear me?
Yes.
Can you hear
Heard
me?
everything.
Yeah, sorry,
you
it was
fine.
down in there.
Can you
Okay.
hear us now?
Veronica, can you hear us?
It's just too loud in there. I'm sorry. I
Are
can't
you
be
able
in
to-
there. And
Are you able to hear us now, Ms. Torres Villalobos?
yeah, I can hear you guys. I
Okay,
just
good.
want to know if you guys can hear me
we can.
or each other or whatever.
Yes, we can.
We can.
All right.
All right. So as I was saying, obviously everyone is aware that we have been trying to get Ms. Torres Villalobos to sign this release of information. The last time that that we saw her quickly in court, and Your Honor talked to her, let her know that if with the offer of the 30 days of jail time, if she did sign this release of information, that she would be getting out of custody today, given that she has been in custody since December 7th. So, we left, Elodie and I left that form with Ms. Torres Villalobos yesterday so that she could review it on her own. She did sign the form. However, the form does say you can cross out any of the partners on this list that you would not agree to share information with. Ms. Torres Villalobos has crossed off many portions of that form and many of those providers. So I told her that she has that form with her. She kind of showed it to me in the video. I told her that I would bring that up, let her show the court and the prosecutor the form that she signed, and
Okay.
I'm sorry. It's not you. It's because these girls are way too loud and it's very
Understood.
difficult to hear.
So
I
Ms.
was
Torres
told, Your
Villalobos,
Honor, I was told by you yourself when I saw you on Wednesday hey, you know what? As long as you sign the paper, you'll get out on Friday. I left mental health partners on there because there are counseling. They can provide me with my medication, with my counseling, which we both agreed that we need. Okay, I did what I had to do. I'm not going to sit there and give permission to release my information to Boulder Police Department. Are they going to be my counselors? Are they going to provide me with my medication and all that? I mean, I'm willing to do whatever you want me to do, Your Honor. I cannot be in here. They won't even get me. I had 2 police officers and Elodie harass me all day about the dang paper. About a paper that they needed me to sign. I signed it. I can show it to you.
Why don't you do that? Go ahead and do that.
Okay.
Yeah, I'd like to ask Ms. Butler real quick. Do you know if the municipal court and the city attorney's office are still on the form?
Did you want to see the signed one, Your Honor, or did you the signed part, or did you?
Because we're okay with her crossing some agencies off.
I'll let
I just think with mental health partners,
we do need to be
included mental health,
the list
and
of
that I do need the help.
they can make her
Okay, let me ask you a
I'm sorry,
question then.
Which one did you want to see, Your Honor? The signed one?
I need to see the signed one, and we want to know, okay,
So it is signed. I signed it this morning. One of the deputies helped me understand it, to understand it more. The only reason why I did mental health partners, and because I want them to release my information. Clinica, I have to do with the face-to-face thing, I guess. So I can't do anything about that. But with mental health, since I do need help because of this, what I told you about, what had happened to me. And everything. I just thought the counseling and the medication and everything that I need, the medications that they're giving me in here, it works for me. They put me on 2 different medications in here, actually. One's the Seroquel, which is at night, but the other one they said is Seroquel too, but it starts with a Q. So for something, I don't know what it is, but that one doesn't make me drowsy or anything, and it helps it. It helps my anxiety a whole lot.
okay.
Especially being locked in here 24/7, Your Honor. Come on.
Let me ask
What
you a
else do you want me
question.
to do?
Let me ask
Yes,
you a
sir.
question.
Yes, sir.
Are you allowing the prosecutor's office to be able to get the information? Did you cross
Yes.
them off? They
Yes.
can? Okay, that's
Yes.
what Ms. Keller was concerned about.
No, I'll let the prosecutor's office with you guys, with you, Chris Reynolds, and Yet. That's fine.
Okay,
I'm
okay.
fine with that, and I'm fine with mental health partners, but that's it. Your
All
Honor,
right.
this is just too much to let everybody else in.
All
This is
right.
more of a legal situation, Your Honor.
Yes, okay, so here we are.
But with you guys, yes, I'll
Hang on a
see you
second,
on
Ms.
Thursday.
Torres, Ms. Torres, hold on a second. Let's hear from Ms. Keller now, so she can say what her position is.
I just want to confirm that it's not only the city attorney's office, but the court, the municipal court as well. So the navigators are able to see that.
Yes, I know that.
Okay.
Yes, I know that. They're allowed. You guys are allowed to do that.
Thank you. I just wanted to confirm.
Okay, you're welcome. Thank you.
Okay,
So
so
now
Ms.
what, Your
Keller,
Honor?
that puts you in the position of deciding whether the offer is available.
The offer is available, Your Honor.
Okay, so what that means, Ms. Torres Villalobos, is if you decide to plead guilty to the one charge that was offered, you're going to get a jail sentence from me. You'll get credit for the time you've been in custody, and you'll be released from our hold.
Today?
Yes.
Are you serious?
Yes.
Can I go by and see you and just give you a big hug?
Well, not yet. We gotta go through the process first. Let's get through the process, okay? So it won't take very long. It won't take very long, but I have to pull up the case. And
But I
then have
won't be
to ask
getting
you
out
questions.
today. You promise?
Yeah, I told you that. Yeah.
I love you.
Okay, so let's go ahead and take the plea.
I'll see you on Thursday.
Okay, let's start
I'll
with
see you
taking the plea. And then we're
I
gonna close
promise
up
I'll see
cases.
you every week. And I'll let you know what my progress is like and everything.
That's what I want to hear. That's really what I want to hear. That's more important than anything else to me as you get some.
I'll see you every Thursday and I'll go see a counselor and everything at Mental Health Partners. I'll keep up with you. I will, I promise.
Okay. All right, let's take the plea then. Let me go over the
No,
case
she
with
won't.
you because I want to make sure that we're on the same track here. So give me a moment.
Okay.
So what the charges that you'll be pleading guilty to is in case number 2022, 3879. And that is, I'm going to pull that up right now, but if you plead guilty to that charge, then I'll be imposing a jail sentence, giving you credit for the time you've been in custody, and all the other charges will be dismissed. Is that correct, Ms. Keller?
That is correct, Your Honor.
Okay.
So, wait, one more question.
Yes,
One more question. So I have no open cases with you guys?
you will not.
It's done now, or?
Not yet. I got to take the plea. So
Okay.
we're getting there.
After today, it will be done.
That is right. Okay, so let me take the plea and go over the charge with you. So this dates back to 2022, Ms. Torres Villalobos, and the charge at the time was obstructing government operations. When you plead guilty to that charge, you're giving up your right to trial and all of the other rights you have in our court. Do you understand that?
Yes, sir.
Are you doing that voluntarily?
Voluntarily, yes.
Is anybody forcing you to plead guilty?
No, sir.
Are you under the influence of any medications or drugs or alcohol?
No, sir.
And do you understand this charge of obstructing government operations?
Yes, sir.
And would you waive a factual basis for the charge, Ms. Butler?
Yes, Your Honor.
Let me go ahead and accept that guilty plea. It is to the charge of obstructing government operations on September 24th of 2022 at Central Park at 1236 Canyon Boulevard. How do you plead to that charge?
Guilty. But I just, because I was here in 2020. Okay, guilty.
I'll accept that.
I got here in 2020. Okay, no, never mind. I'm sorry. I'm thinking of the wrong year because September 25th is when I got back from Texas. That was in 2021.
Yep.
Because I was in 2020, I was in Texas, but I was only there for a year and a half, but I got here on September 25th, which was on a Thursday. So that's why I was like, wait a minute now, but you said 22 or
Yep.
2022, right? Okay, so
Yep.
yeah.
So you plead guilty to that?
Yes.
All right, I'm going to accept that guilty plea. Any further comment from you, Ms. Keller, or from you, Ms. Butler, before I impose sentence?
My only comment is that we just need to get a copy of that ROI.
Right.
So she can hand it to an officer and then email it to me or Mr. Reynolds. We just need to get it somehow.
And so, Ms. Torres Villalobos, do you have that document? Can you give it to the officer?
I'm gonna talk to her because I don't.
Okay, do you want to talk to him and tell him?
Yes.
Hold on.
Hi, I'm sorry. Officer
Officer,
Middlebrooks.
it's a
what-
little
what
bit of
can
an
I do?
unusual process, but we're working here with Ms. Torres Villalobos and Ms. Molina. She's going to
Sure.
give you that signed document the document she signed.
Okay.
And then if you would do the favor to the city attorney's office, they can email to you, and then you can email back to them once you have their email contact. If you'll scan and email that back to their office, they need to have that as part of the plea agreement.
Your Honor, I would like
Okay,
to be
and this-
CC on that scan copy as well, because I do need to upload it for the high utilizer.
We'll rely on me to get that to you.
Yeah, and officer, can you just spell your last name for me so I make sure I have the right?
Sure. It's MIDDLEBROOKS.
Awesome. All right, I will send you an email. Thank you so much.
Okay, and ma'am, I'm sorry, am I forwarding this to you then?
Yes, if you forward it to me, I'll pass it along to Neot and then Mr. Reynolds from our office.
Okay. Perfect. Thank you, ma'am.
Okay. Any other comment before I impose sentence? Ms. Keller?
Nothing from Your Honor.
Thank you, ma'am.
Ms. Butler?
Hello. Hello.
So I would just say, perhaps, I would suggest that perhaps the minute orders from today or the sentencing order or something reflects what was said on the record and what Ms. Torres Villalobos agreed to. It may be unclear based on the form that she signed,
So
but
painful.
what she verbally kind of agreed to with agencies and partners she's approved for that release of information. Perhaps that clarification should be included in the minute orders that can be, I guess, attached to the ROI or something.
It'll be in our register of actions. I'll put an order that reflects that, and to make it clear, rather than impose the jail sentence that was requested of 30 days, I'm going to make it a 21-day jail sentence that will start on December 7th. That way it'll be clear with credit for time served that Ms. Torres Villalobos is entitled to be released from custody today. So it'll take them a few hours to do that, Ms. Torres Villalobos. You're going to have to be patient. So don't expect that to happen momentarily. It'll take them at least 2 or 3 hours to get you released.
That's fine. Thank you so much, Your Honor. I'll see you on Thursday for Deacon's Closet, and I'll give you a report about.
I would love to see
Thursday next week.
Yes.
Happy New Year's. I love you, and I'll see you next week.
All right, and keep up on, I want a couple of more things to just say. I want you to keep up on your promise now of staying on those medications. They're helping you. And I want you to meet with mental health partners. Those aren't orders from the court, but that's what I really want to see you do. That's more important.
And I'm gonna keep my promise with you, and I'm gonna start staying at the shelter every night and order myself. You should put that in the order too. That I have to stay at the shelter every day, every night, so I don't mess up, so I can take my medications. Hopefully if they can help me. If I get out early enough, it's 11. If I get out early enough, I could go pick up the medications today.
Yes. Okay. Well,
so if I can get out early enough,
that's what's really important.
I think. Yeah, so if I can go get it, then mental health partners will definitely help me. From what I was told here at the jail, mental health partners will help me. I just need to get a prescription or whatever for the start post or whatever, and I'll be fine because I'm taking Tylenol and naproxen for 30 days.
Okay.
So I got a lot of medications to fill. So if I can get out here by the time they close, that would be great.
All right. You've made some really good progress.
I will stay at the shelter every night. And I'll keep up with my counseling and everything. I won't let you down.
Okay.
Okay?
I appreciate
Thank you
that.
so much, Ron. I love you.
Okay.
Thank you so much.
Thank you. All right. Officer, we'll be ready for the next defendant. Thank you for your help.
Wow. She was just like that in the last hearing. Luckily, Chris wasn't here. She brought his name up, but she loves the prosecutor, Chris Reynolds. Hi, Chris. Oh, man. So this poor judge, he's going to quit soon. You can tell because she's going to see him every Thursday for a drug court or whatever they have there. And she has to update him on her progress. First off, she's not going to go. We all know she's not going to go. But if she does, that poor judge, oh my goodness. Okay. The next case I have is great. It's just an emotional roller coaster. It really is. But don't worry, I wouldn't put anything bad on here. Just wouldn't. So, it's the same judge, which is like he's hard this time. He's not a pushover. You'll see.
This is Moonshadow case. We have Mr. Reynolds here for the city, and I believe, are you Moonshadow? I am. All right, good morning. Ms. Shadow, I was aware that there was a motion for forfeiture that was filed in this case. I believe you received a copy of that motion for animal forfeiture. Did you get that copy? No, it would have just been in the last couple of days that you received that.
I believe probably.
Just so you know, at the very end of this case, that's when you find out a whole lot of information that would have been helpful as we're watching, but I'm not going to tell you.
This is what I received yesterday, and it's a copy of October's court paperwork.
The motion that I'm talking about perhaps had that as part of it, as an attachment to the motion. I want to make sure you have the actual motion as well. So let me pull that up, and I'm going to ask when our clerk comes back in, ask to have that printed out. Mr. Reynolds, did you want to chime in on that as far, because you perhaps were participating?
One of the, I highlighted what the title of the document was. Those are the papers I gave her yesterday.
Why don't you come on forward, and we'll have you both come forward, and I can just take a look at what you have. So bring everything that you've got. I want to just see what you have, Ms. Shadow. And Mr. Reynolds can come forward as well. If you don't mind, I could just kind of take a quick look at everything, and I'll give it right back to you.
Thank you.
Yes, okay. So what I was referring to is this document here.
Okay.
So that's the motion for animal forfeiture that was filed by the city. And then all of these other documents were attachments to the motion. So those were things that they provided to support their position, asking for the court to order forfeiture of your dog. So I just wanted to make sure that you had a copy of this and you'd had a chance to read it. I'll give it all back to you. And you can go back to your desk. I just want, oh, and oops, I'm sorry, I've got one more document.
Thank you.
Okay. So from the court's vantage point, this has happened relatively quickly. So I wanted to make sure that you had an adequate chance to look over the document and understand what's contained in that motion for animal forfeiture.
I did, and I made some notes on it because there was a few inaccuracies. I was told not to put my hands anywhere where they couldn't be seen and to put everything that I had on top of the dash. And I did what was told. And before I even vacated the vehicle, I told the officer my dog was wrapped in the blanket next to me, and I needed to put, he has a car securement that plugs into the seatbelt, and I always use that to keep him secured. It's got a lead about this long, so he can't move and he stays safe. It's part of his doggy car seat. And I asked them if I could please attach him. He said no. And then I said,
so I'm going to give you a full chance to be heard today. I don't want you to worry about that at all. You're going to get a chance to tell me everything that from your vantage point as to what happened. And I know what's contained in the report in that motion comes from the government's perspective, what they think happened, but you'll get your opportunity and they'll actually be putting on evidence as well. So I don't want you to get too worried about this at this moment, but you will have an opportunity to share with me what you want me to know. I wanted to start with just making sure that you've had a chance to read that document and the attachments.
yes, I did. I was over it last night until I fell asleep.
Okay. The other question I have for you is, because I wasn't involved in scheduling this hearing, ordinarily we schedule these out over more than a few days, but it was my understanding because of the dog being held at the shelter that everybody wanted this to be resolved quickly, including you. Is that correct? You want this issue to be resolved? Because otherwise your dog will remain there until we have the hearing. And so there's no guarantees of what's going to happen at the hearing today, but I wanted to make it an expedited hearing so that we could resolve the issue quickly one way or the other. Does that make sense to you? And is that how you wanted to proceed as well?
I would like my baby to be home as soon as possible, if that's at all possible.
And I understand that's probably your goal, but with that in mind, are you comfortable going forward today as opposed to continuing this on to another date? Okay. I just wanted to make sure that I made you clear that if you needed some more time to prepare, we could schedule this off, but it would be a week or 10 days from now.
I contacted my lawyer as well, but she won't be in the office until the 4th. I did send her an email of the current situation. I'm hoping that we can get it resolved, but I just need to make sure my boy is safe.
Okay, give me just a moment.
She said she contacted her lawyer. Now they all have to stop what they're doing. She can't go to jail in this hearing. So she doesn't have to have a lawyer. Like, they don't have to let her have a lawyer. I should say they don't have to continue it for her to have a lawyer. She can have one today. She has a right to a lawyer.
Okay, I wanted to just take a look at the history of the case so that I was the other case that you had with our court. And so I wanted to be aware. I haven't ever seen an attorney enter an appearance in any of the cases, and that's what I was checking. The attorney that you mentioned, is it somebody that you had anticipated that you might be hiring in connection with this? So let's talk about this a little bit. I want to make sure you understand. If we go forward with this animal forfeiture hearing today, after I've heard the evidence, there won't be a second opportunity for a hearing after this. Today will be the evidence that I hear. So even if your attorney comes in and says, gee, I want to represent, and is it last name is Moonshadow or is last name Shadow? Shadow is the last name. All right. Yeah, so I want to represent Ms. Shadow in this case. I may have already issued a ruling on it. So there won't be an opportunity for a lawyer to come in and say, now I want to start the hearing over again. It's not going to work that way. Today, if we do the hearing today, this will be a final resolution of the case. Do you understand that?
I do understand that.
Okay.
I would definitely like an opportunity to speak with Ms. Plea concerning the situation. So on my ticket, it says that he doesn't have any licensing or rabies vaccination. I got him his 3-year vaccination last year. I have it on my Google Drive. As well as if you look at the reports from his previous instances, he was never actually in my care or control. He's never had a bite incident in my care and control.
So let me keep you focused on just this one issue, which is what you've described as you may have received a ticket. That yellow ticket that you have in front of you is a citation, and that has a date where you're supposed to appear on that criminal charge.
Yes, it's for the 9th of January.
So that's separate, although it's all connected in the sense that what happened when you got this ticket also led to this forfeiture hearing. That's a separate event. That's a criminal case. And if you decide that you want to have representation and have, did you say Plea?
Yes.
If you want Ms. Plea to represent you on that, that's perfectly fine. What I'm talking about is this animal forfeiture hearing that we're about to do. I want to make sure you understand if the city attorney presents evidence and then you present evidence and I decide, okay, the animal should be forfeited to the city, that will be my order. And that means you might not get your dog back. If I decide the other way, that you get your dog back, then that will also be my order. But it won't be something that I say, okay, next week because Ms. Plea was gone, she gets to come back and have the hearing again. Okay?
I agree. Okay.
You understand that?
Yes, I do understand that. I guess my best option would probably be to postpone if it's possible.
So I think the fact that I said this to you, I think it is possible. If you're anticipating that you might want to hire Ms. Plea to represent you in connection with this animal forfeiture hearing?
Yeah, considering that Rollo doesn't have any other chance of living without me, I need to make sure that I'm doing the best thing by him because it's not his fault. He didn't do anything wrong. He ran back to the first place that he thought that he would find me, that he thought he would be safe. And he never had an incident in between that place and the place he was finally caught at. And he's not aggressive. He's protective and he's terrified. He was traumatized. And he's not really been treated as a traumatized dog. He's been treated as a menace. And he knows he's targeted. He knows that he's viewed as a bad boy, and he's been trying. And so I feel like I should definitely consult with my lawyer to make sure that I'm doing the right thing for him.
So, Ms. Shadow, let me ask you another question. Obviously, you have not actually spoken to Ms. Plea.
She won't be in until the 4th.
The 4th. And so, if she's not going to be back until the 4th of January, which is next Thursday, there's no possibility of even having a hearing on this until another week beyond that. Sometime in the following week would be the earliest date that would really be feasible to have a hearing. And that means that your dog would remain at the shelter for that entirety. That may not be a good place for your dog or good for the shelter.
It terrorizes him. If I could try to get it set for as soon as possible after the 4th. I feel like.
Ms. Keller, would you mind asking Greg Ogden or clerk to come in just so if we do have to reset, I want to at least be prepared for that. Would you just mind stepping out to, thank you. I'm going to give you a chance, Mayor, Mr. Reynolds. I just want to make sure I've covered everything that I want to cover with Ms. Shadow.
Can I ask Ms. Plew's, what is her first name and how do you spell her?
P-E-L-L-O-U-X.
P-E-L-L-O-U-X. I'm sorry, you said her first name was?
Carolyn, C-A-R-O-L-Y-N. I think I'm missing something in there.
Mr. Ogden, I just asked you to come in so that we're having some discussions right now with respect to whether to go forward with the hearing today or not. So if we decide, and I have not made up my mind as to whether we will go forward today, but I wanted you to be present with if questions came up about scheduling and things of that nature.
Sure.
Okay, anything else? So let me make sure that I understand what your position is then, Ms. Shadow, is what I've been talking to you about is basically you asking me to continue this hearing on to another date. And it would be a date that would not be before January, probably 10th of 2024. So that could be, we're talking about almost 2 weeks from now. And your dog has been at the shelter since the 25th of December. So are you requesting that I continue this hearing on to another date?
I am, and that I might be able to at least have visitation with him while he's not in my custody.
We can talk about that. I have that would be a separate issue that I would have to decide as to whether to allow you to at least see your dog. I have not heard from the city yet on this request to continue the hearing. Mr. Reynolds, it's somewhat of a unique process that we're in here because of the nature of the request that you've made. If I understand, it's a show cause request, not necessarily under a particular provision of the city ordinances, but perhaps you want to articulate further on that.
Thank you, Your Honor. I would suggest that we are kind of squarely under ERC 6127 administrative forfeiture. There could have been a show cause filed on Mr. Edwards' case, but the city's interest here is acting quickly to determine what's going to happen to the dog, primarily for the safety of the community. And then as to the continuance request, we have Officer Whittle here who has some information about the status of the dog, what the dog is currently able to do and not able to do at the shelter, and if it would be helpful to the court's determination as to whether or not to grant the continuance. We'd be happy to call Officer Whittle to the stand to testify for that limited purpose.
All right, thank you for that, Mr. Reynolds. I think it may be, but before we do that, perhaps you could kind of take a look at section 6127 for me, and I'm just now pulling it up and looking at it. What Mr. Reynolds has described, Ms. Shadow, is the provision of the Boulder Revised Code. It's section 6-1-27. Perhaps, is that a code book that you have there? We usually had one. We used to have one on both desks.
Yes.
Would you mind opening that up to section 6-1-27 for Ms. Shadow?
Oh, yes.
I've never seen them do this before. This is nice. She's not going to understand
perhaps
it.
follow along
nice.
with me.
6-1-27, and then that's the title of the ordinance, and you can see that's also referenced in the motion we got yesterday, and so this would be the law basically the judge is applying here.
So let's, Mr. Reynolds, you believe that this is the section under which you would be proceeding. And so I'm just looking at section 6127B, which basically, and subsection A indicates, Ms. Shadow, for your purposes, that this is a method by which the city can seek forfeiture of an aggressive or abused animal in addition to other methods of forfeiture and impounding. And then it says under subsection B, whenever the city manager or its delegate, and that could be a person who works for the Boulder Police Department or in animal control, they're all part of that city manager umbrella. Whenever they believe that someone is vicious, as provided under section 6120 of the Boulder Revised Code, or neglected or under section 616, and then there's a couple of other provisions, they may apply to the court for an order to impound the animal and remove it permanently from its guardian. And then the application would be, and that's in the form of the motion that you received, identifying the animal, identifying the guardian or keeper, which would be you, the date and location of an occurrence of one or more acts of viciousness, and request that the guardian be required to show cause why the animal should not be permanently removed from its guardian and forfeited to the city. So that's the provision that he's operating under 6127. And then the court is required to set a hearing once that motion has been filed and it's been established that you've been served. All of that has occurred. The motion has been filed, you've been served with the documentation. And then at the hearing, it would be up to the judge to decide whether the animal was vicious within the meaning of section 6120 or was treated in a manner prohibited by section 616, which is to subject an animal to unnecessary suffering or improper care. And then the court could order forfeiture of the animal. Mr. Reynolds, this provision, 6127, doesn't require the hearing occur within a certain amount of time because I think what's presumed at that time is that the animal hadn't yet been impounded, but there's also the provisions for the animal to be impounded and then for a hearing to occur. And so in my view, it's really a combination of 6127 and 6128.
And Your Honor, I would agree with that. And so like I stated, I think there are kind of multiple avenues. Ms. Machado could have requested an impound hearing, and then we'd basically be we'd be talking about the same things. It's just no request was made, but because of the history and circumstances, we just decided to file the civil forfeiture and go that route.
Okay, good enough. So before I make a decision on whether to grant the request to continue this hearing, which I believe I have the authority to grant the continuance request, I do want to give you a chance, Mr. Reynolds, to present whatever evidence you think might be helpful in that regard. What I have from Ms. Shadow is basically her desire to have counsel, to at least consult with counsel who she has not been yet able to consult with before the hearing goes forward. So that I'm going to be weighing that against any other position that you might take. But if you'd like to call Officer Whittle.
Yes, so I'd call Officer Whittle to the stand.
And Officer Whittle, if you'll come up and just have a seat at this area here. I believe we've got it a little safer than it used to be, so it should be fine to get in and out of there. And just a reminder, when you're getting in and out, I hate to do this, but because we have this TV right behind you, make sure you don't hit your head.
Yes, I rarely hit my head up.
Sure. So if you'll raise your right hand for me. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Right, thank you. Go ahead, Mr. Reynolds. And for your purposes, Ms. Shadow, if you have questions that you want to ask the officer, you're going to have a chance to do that after the questions have been asked by Mr. Reynolds.
And thank you, Your Honor. Good morning, Officer Whittle. Can you state your full name and spell your last, please?
Sure, Jenny Whittle, Whittle.
And Officer Whittle, where do you work?
City of Boulder Animal Protection. I'm the supervisor of the animal team.
And how long have you been in that role for?
Almost 2 years.
And how much experience do you have with dogs?
Before being supervisor at Boulder, I was an animal management officer for the city of Arvada for 10 years. And before that, I was a kennel technician and the behavior coordinator for an open admissions shelter in another city.
And how long did you work at that animal shelter for?
The animal shelter was about 4 years, and I assessed dogs primarily for adoption or rescue or euthanasia or behavior modification, and created enrichment and behavior modification for dogs in the shelter.
And are you familiar with a dog that goes by Rollo?
Yes, Rollo.
Rollo.
Yes.
Rollo. How are you familiar with Rollo?
I first met him in September for a dog bite case, and met him again for a concern in November, and then most recently the Christmas case a few days ago.
And where is Rollo right now?
Rollo is impounded at the Humane Society of Boulder Valley.
And are you familiar with the Humane Society of Boulder Valley's kind of procedures on when they have a dog that's like Rollo?
Yes, I recently even did a behavior shadow with them, and we communicate well as far as which dogs are able to have enrichment, go on walks, have visits, be adoption candidates or not.
And can you talk about those things with regards to Rollo?
Yes, Rollo is indeed a fearful dog, and he is with his guardian's permission on anti-anxiety or some type of medication at the shelter currently. He is not a candidate for walks with volunteers or staff because of his fearful behavior, so staff is not comfortable walking him for their own safety. Rollo does eat and does get enrichment in his kennel, so he is safe, but his fearful behavior makes impoundment for long periods of time not ideal for his well-being, and he is not an adoption candidate due to his fearful nature and aggressive past incidents.
When you say that he's not a candidate to be walked, and it's not ideal for him to be impounded for long periods of time, can you talk a little bit more about why that's what makes you say that's not ideal? Like what's his day-to-day like?
Sure. Since he is not able to go outdoors for regular walks while at the shelter, he is missing out on that opportunity, but it is in the interest of his own safety. If he were to escape on a walk, he's very difficult for others to catch. When he did jump out of the car Christmas Day, it took an infrared drone, several police officers, and several hours to have him be caught. So he is fearful enough that it would be difficult or dangerous if he got loose, even if he were comfortable with staff. If he is uncomfortable enough to bite a staff member, it obviously puts them in danger, and then he and the other animals are not getting the care they need if they're short-staffed. And emotionally and physically, it is stressful for a dog to live in that sort of a situation if it's not just a temporary holding time period.
And how would you describe Rollo's quality of life at the shelter right now?
I think that although it is the best case for public safety at this time, his quality of life is poor being in that kennel environment.
And based on all of your experience working in a shelter, being in various animal protection positions, do you, if Rollo was held at the Humane Society in his current condition for, let's say, 2 more weeks, would you have any concerns?
I would have concerns. I would prefer to expedite because he is not thriving in that situation.
And just to be clear, are you aware of who Rollo's guardian or guardians are?
I know Sarah by Sarah's name, Moonshadow, and her son in the past has also taken care of Rollo Nicholas Edwards.
And I don't believe I have any other questions, although is there anything else you would like to add to this conversation?
I am aware that the Humane Society will not allow visits at this time, so if that's another consideration for Rollo's guardian, no one is allowed to visit him just to prevent accidental escapes or him being loose within the shelter or staff having to interact with him if he's not comfortable with that. So there are no citizen visits with him, even for guardians at this time.
Thank you very much. I don't have any other questions for you, Officer Whittle. Perhaps Ms. Shadow may.
Ms. Shadow, go ahead if you've got questions for Officer Whittle.
My only question is that when he was loose, did he have any interactions with anybody else, like any negative interactions where he had accosted or injured anybody between Folsom and Pearl, and when he ran back to my place of work and my client?
As far as we know, he did not have any negative interactions or contact any people when he was out.
I feel like that's important. He's been making exceptional advancement in his behavior, and since Thanksgiving, he had made a new friend just about every day. And he did have all of his securements.
Before you go off, because you're starting to tell me some information that you're telling the court, just keep it to questions for Officer Whittle, if you will.
Was he brought in with his securements?
He has his collar on and his harness with a leash attached.
Did he have his martingale muzzle attached to his collar?
I don't know what type of collar he's wearing, if it's plain or martingale, but he has a circular piece of fabric around his neck, which is otherwise identified as a collar, and then his body harness, which did have the leash trailing.
All right. Thank you. I think that's it. I can't think of any other questions that I might have.
Okay, give me just a moment, Officer. I might have my own questions, so I'm going to try to think of what else I might want to know. Because I haven't been out to the shelter to see where Rollo might be held, can you describe where he's being held and how that relates to others who might be taking care of him, or even visitors, how that would, what that looks like?
The kennel isn't, or the shelter is indeed certified as a fear-free space, so they have extensive training and tools to make every animal stay safe and humane. The kennels themselves are double-sided, so they're front and back for adequate space, so dogs can eliminate on one side and then have their bedding and food and water and toys in another. But the kennels are all adjacent, so any dog that passes by has to pass by every time they leave. And the kennels are indeed pretty full right now, so there's a dog in almost every kennel on either side of Rollo. Staff members enter through a door and can separate dogs for cleaning by closing their slider door in the center, so they get cleaned on the backside with that slider door closed, so there's no physical interaction if they can't have it, and so they can be cleaned and maintained in the front, and then the sliders open to give them their double side back, their dogs are fed once or twice a day depending on their needs. They always have fresh water and bedding. Toys that are safe so they won't be destroyed or ingested, and medication as needed or authorized by the guardian or veterinarian as far as any anti-anxiety or any pain meds an animal might need.
From a personnel safety perspective for the folks who work there, are they the only ones, if I'm reading this correctly, other dogs he doesn't have access to other animals?
Correct.
But he would at least at a time when food is being placed inside, can they do that safely, or is
They can. The slider door is utilized to separate dog from human for energetic dogs, scared dogs, aggressive dogs, escape artists. So they do have the option to have the dog on one side, close the door so that they can have free range to open their kennel door to clean, feed, or otherwise place items.
So there's no one who has to be at risk of being bitten by Rollo while he's in custody. Is that correct?
Correct.
And then from a cleaning perspective, I own dogs, but I don't know, or been a guardian for dogs, but I don't know what is expected for the dog's health over perhaps a 2-week period if I were to extend this hearing 2 weeks.
Sure. It is not so much physical or cleanliness as far as his emotional and stress levels. So I think for a fearful, anxious dog, being away from his guardians or known family, the noise and commotion is an added stressor, and the isolation, since he's not allowed on walks, is a major consideration for his well-being. And although he and staff come first, it also still impacts the community because he is reserved a space indefinitely or until a hearing is set. So he cannot be moved or rehomed or euthanized or adopted or returned until that hearing. And that way he is made to take up that kennel space from maybe a different bite case or an adoptable pet that could use the space, or an owner who has passed away needing to surrender their pet, for example. So.
And you mentioned that the kennel is basically full. There's no.
Yeah, the shelters are generally quite packed at this time of year and time of the state of the world. Though the shelters are very full.
Okay. You indicated that the shelter right now is not allowing any visits. And I was taking some notes, but I didn't quite get down all of the reasons. Can you describe those again for me, why they can't take any visits?
Specifically for Rollo. So
right.
Rollo's guardians are not allowed to visit him. They explained to me that it is primarily safety so that he doesn't accidentally escape his kennel and is running free within the shelter or escapes outside of the doors. If a guardian is visiting and not shelter staff, they may not. I think they're worried that the door may be inadvertently opened, or the guardians wouldn't have the knowledge of how the shelter works, or how to prevent escape, or perhaps they are worried about intentional removal.
Well, I can see why they would not want to delegate the authority over the area where a dog would be being held. And so there wouldn't be an opportunity for a visitation that would just be outside of the kennel.
I think, again, ultimately it's up to the Humane Society,
right.
But due to the emotional state of guardians surrounding this case and the fearful nature of Rollo, they still feel even a visit in a separate room could not be safe if staff has to walk Rollo and he is fearful or aggressive with staff to even get him to that room.
So they can't, the guardian couldn't go up and be outside the cage and say hello in that way. I'm talking about not having physical contact or access.
I think that as a physical barrier, that could be a safe alternative. However, I wonder if the emotional stress of seeing his guardian and then having her removed again would possibly be worse for Rollo.
And also the impact on the folks at the kennel having to make sure that they're making that available and how that might impact their work as well. So I just wanted to get a sense of it all as I'm thinking it through.
It is emotional. I understand that, and we are all trying to be sensitive to that, but they do want to ensure their safety, and and thinking about Rollo's well-being, visiting is sometimes harder for for animals. Because we see it one way, but in their mind, they don't have the same concept of time or understanding of our situation.
Is there any evidence of Rollo's health being diminished over the last week? Not quite a week, I guess it's been 4 days that he's been in custody.
Physically, no, he seems to be eating and eliminating properly. I visited him yesterday and possibly the day before. I fed him treats through his kennel, and his posture is very hunched and fearful with tail tucked, and he is full of uncertainty and seems anxious in his behavior. So emotionally, he does not seem to be thriving.
You'll get a chance, so don't worry. I'm going to give you both a chance to follow up after my questions here. You mentioned that he's not a candidate for adoption. Is that your determination or also something that you've gleaned from the folks at the Humane Society?
That is completely their determination. So if he were surrendered willingly by a guardian, they would not adopt him out. If he were court ordered, they would not adopt him out. So if he is custody of the Humane Society, they are not comfortable placing him in a new home within the community.
And that means what I'm reading is that would probably be a humane euthanasia.
Yeah, he will be humanely euthanized if he is their property.
Okay. All right, that's very helpful. Thank you for answering those questions. Mr. Reynolds, any questions based on my questions?
No, Your Honor.
Ms. Shadow, any questions based on my questions? Just questions for her, and I'm still going to give you a chance to be heard. So if there's things you want to just tell me, you'll get that chance. But if there's questions for Officer Whittle, that's where we're at right now.
I had something and I can't think of it now. Does he show any signs of improvement to you compared to the last 2 times that you had interaction with him?
I can't fairly answer that since my interactions are very limited. I don't see him as often as you do living with him. So I don't have a measure to say if it's improved or not. He barked at me through the car window in November when I met you and Nicholas and Rollo, and in the kennels he is quiet but anxious. That's about the only observations I have that I can add.
Can I make a comment?
You will. But just a question for her. And you hang on to that. Put your mind around it. And you have a pen there, so feel free to make some notes if you need to. So you're.
That was the only question.
Okay. All right, you can step down, officer. Thank you. Mr. Reynolds, I know you've put it in the motion, but if you can make a brief offer of proof and argument as to what your position would be with respect to this case, and then I'm going to give Ms. Shadow an opportunity as well. This will not be the full hearing, but it may be part of it, depending on whether we decide to continue.
Our ultimate position and
yes.
What would be, so yes, Your Honor.
And the basis for your, I'm wanting to know what basis you have to believe that there's been something that justifies the ultimate order of forfeiture. You placed it in the motion, but if you could just summarize that again.
So essentially, Your Honor, this dog has been involved in 2 bites to humans in the last couple of years, most recently in September of this year. And that bite incident was a bite to a woman's arm that broke bones and a bite to her stomach. And it was, so this dog's been on animal probation in our court twice. And in the most recent case, the one from September, is under extremely stringent requirements, including having multiple ways to basically grab the dog, a harness and a collar and a leash, never being allowed off leash under any circumstances, suspended forfeiture for 24 months. There's actually, I believe, suspended jail on this case as well, because we really, really, really wanted to drive it home that these were the management strategies needed to ensure that there wasn't a future bite incident. And this is a large dog. That's the proof that would happen. A large, powerful dog. And on Christmas of just a few days ago, the dog, as Officer Whittle was saying, was at large in our community again, and that took multiple police officers using a thermal drone to capture it. And I am extremely sympathetic with Ms. Shadow and her background and this dog's background, but ultimately it's for the safety of the community. We feel like if the dog is released back to Ms. Shadow, that despite really Herculean efforts, the dog's very likely to get out again, and we don't want it to kill someone or to maim someone. And if it bites a kid, very likely could kill a kid. If it bites an adult, could maim them. And that's ultimately what our position is. And our filing is, we would consider it to be almost an emergency filing, because we don't want this animal re-released. And we feel like if it is released, despite whatever Miss Shadow does, the dog's gonna get out again, and we don't want there to be a third bite. And so we would be ultimately asking for the court to forfeit animal to the Humane Society and let the experts decide what the ultimate outcome is, which I think we can all kind of understand would be the dog wouldn't be able to live out its natural life. And that's tragic, but it's not as tragic as another bite happening involving this dog.
Okay, thank you for that, Mr. Reynolds. All right, Ms. Shadow, anything else that you'd like to say? Now, we've heard from Officer Whittle. I want to share with you that if I grant a continuance, which I have not decided yet, but I want to make sure you understand that there won't be visitation. So that I want you to understand that as we go forward here, is that there won't be an opportunity for you to see Rollo while this case is still pending. And that's because of what Officer Whittle described as the safety, but also the emotional impact for everyone concerned. The folks who are trying to do their jobs at the shelter, you, and for Rollo, more importantly, that how that might all impact him, but primarily from the safety perspective. So there won't be visitation, even if I do grant a request to continue. I wanted to make sure you understood that before you finalize your position.
I would like to make note that he was in quarantine for 10 days, and we visited him twice a day, every day. And there were workers there that said that he was sweet and they loved him and he was affectionate. I have a lot of people who are willing to come on his behalf concerning how much they've seen him change with working with him. This is not his fault. This was not my fault. I just can't let him go. He's all I have left now. Everything else is gone. It's like we should have died there because everything else is just being torn away one piece at a time. And he's all that's left now. And he's never had a bite incident where it was just random. He was always trying to protect my daughter, myself. It had never been random. He's really trying. He's a good boy. He is. And he, after experiencing Shadow's labor and delivery and experiencing the baby's birth and stuff, he really was actually trying to make new friends every day, a new friend every day. He was very happy whenever we would discuss it. Like I talk to him like I talk to anybody else. I tell him how proud I am of him, that he's trying. I can't go on without him. He's all I have. My kids aren't even with me now. They're just... If I thought that I was able to trust my son fully, he would have remained with my son, but my son he's angry and depressed and doesn't always handle it well. And I was concerned for his safety and his well-being. So I took the chance and I took control of him. And we were only passing through Boulder so that I could get to a client in Weld County and then get to where we had been staying. And unfortunately, it didn't turn out that way, but it wasn't because orders weren't followed. I had everything that I was court ordered to have for him. His securement and extra leash, all of his martingale. He has a martingale muzzle, a martingale harness, and his martingale collar. He was wearing all three. He also had his extra leash attached to him, as well as his car securement, which unfortunately I was not allowed to attach to him for his safety. I begged them not to risk my baby's life. I begged them to the point that I had a panic attack and then was assaulted. And I'll do whatever it takes to save my boy. He's the only thing I have left. My clamming chain is dead. My kids are split up and I don't have anybody else.
All right, Ms. Shadow, I have a question for you then. Are you maintaining that you'd like to have this hearing continued, understanding that there's a likelihood that if I do continue it, you are not going to see him during this period of time? And if I do continue it, it won't be for longer than is necessary to allow you the opportunity to consult with counsel.
Yeah, I understand that. And as much as it's killing me inside, I'm gonna do whatever I have to save him. He would do the same for me. He loves me, I love him. He's my everything. And he does not bite at random. He was trying to protect us. He was trying to protect us whenever we were in the shelter and we were being targeted and the community worker was not helping us. He was trying to protect us when he was confused and heavily medicated on medications that they knew he would, they said specifically that his inhibitions would be lowered from those medications. That was their choice. I never asked for that medication to be given to him. I feel like if they had known that he would be a problem, if they'd known that his inhibitions would be lowered, then they should have maybe maintained control of him until those medications were through his system. And because we weren't prepared for that. I tried to explain it to my daughter. I was trying to catch up to her. She walked out the door, and as soon as they both turned around, they were confronted. Let me stop you because I know we're diving into other issues. Yes. And I want to be thoughtful about where we are with this issue. It's the one issue that's in front of me right now is whether to continue this hearing over. So if I understand you correctly, you make note that he's never just randomly acted out in violence. Okay. It's never been random. I understand that position that you're asserting. I understand it. Mr. Reynolds, any other comment that you'd like to make?
Yes, Your Honor, just as for the continuance, people have can be represented by counsel, but they don't have rights to counsel at a proceeding like this. And Ms. Shadow stated that her attorney that she knows isn't getting back until January 4th. In my experience with attorneys and their schedules, it would just be very unlikely that Ms. Plea would be able to just jump right in and do it like a hearing the next week. Usually when an attorney enters on a case that is kind of midstream, they file another motion to continue, so let's say that Ms. Plea would be interested in helping Ms. Shadow with this, but that her schedule wouldn't allow her to do a hearing in the next 3 weeks. And so this dog could be at the Humane Society in these poor conditions for perhaps weeks and weeks. And I understand it's a balance. But again, this hearing doesn't really implicate, a fundamental right of Ms. Shadow. She's not in danger of, losing her liberty. She's not in danger of getting a criminal conviction here. It's really just to determine what happens to this animal. And I think that the court should consider kind of the strength of proof and offer of proof as it knows it right now, determining whether or not to grant a continuance and whether or not having an attorney in a month would make a difference based on the facts that have already occurred.
Okay. Thank you, Mr. Reynolds. I'm going to take a brief recess for about 2 minutes. I want to gather my thoughts, and then I will come back and rule on that request to continue.
He, in fact, did not take 2 minutes. He was gone for a long time, and I'm just biting my nails waiting for this judge to come back.
We were on the record on the case number 2023-5459. It's a motion for animal forfeiture that precipitated this hearing. The issue before the court right now is whether to grant the defendant's request to continue this hearing. I have heard testimony from Officer Whittle, an offer of proof from Mr. Reynolds, the city attorney, and some statements from the defendant regarding the condition of Rollo, who's the animal in question here, and the circumstances surrounding Rollo's impoundment, Rollo's subsequent treatment at the Humane Society of Boulder Valley, and his condition at the Humane Society of Boulder Valley. This motion for forfeiture, although it didn't specifically identify a provision, the code provisions that in the court's mind apply are section 6127 of the Boulder Revised Code and section 6128 of the Boulder Revised Code. And as the court's understanding of what took place is that Rollo was in the custody of the defendant. The defendant was then was in her vehicle and was taken into custody herself. At the time that she was taken into custody, the police department attempted to take into custody her animal, which is anticipated by Boulder Revised Code sections throughout the provisions of the code. During the time of that custodial situation for the animal escaped and then ultimately was recaptured and then impounded after the recapture, and has been at the Humane Society of Boulder Valley since December 25th. On December 27th, the city filed its motion for forfeiture. The motion, if I understand it correctly, was served on the defendant on the 28th, which was yesterday. And then yesterday, it was also the time that the court scheduled a hearing for today for this animal forfeiture provision. So it's happening relatively quickly. And as the city has pointed out, they view it as an emergency impoundment and an emergency motion because of the nature of the situation with Rollo, that Rollo has had 2 prior incidents of aggressive animal and is an anxious and fearful dog that could harm another and is actually being cared for at the Humane Society based on their concern that the animal could harm even a person with experience dealing with Rollo. And so it certainly does require an immediate resolution if possible. And Mr. Reynolds has pointed out accurately that this motion for animal forfeiture comes under the provisions of the civil procedures for the court. It's a section 1-3-1 provision. A quasi-judicial hearing is anticipated to determine whether or not the animal should be forfeited. And that is a civil procedure, so it doesn't mean that someone has an absolute right to have counsel, and other constitutional safeguards that are in place for people who might be facing the loss of liberty in a criminal case aren't necessarily available to someone from a constitutional perspective when addressing a civil matter. Having said that, and acknowledging that in fact this is a civil proceeding, this is an animal, it's a living being that we're talking about, and it's one that if the court finds in favor of the city on a forfeiture provision will result in the loss of that animal's life. And so although it is a civil proceeding and an animal is technically considered to be property, it's not the same as if we were talking about a vehicle or someone's personal property. This is a living being that we're talking about. And so from that perspective, the courts and has always erred on the side of procedural fairness when it tries to decide what to do next. And from a procedural fairness perspective, I think it's important to give the defendant at least an opportunity to secure counsel. I am not required to allow counsel to continue this hearing on beyond a date that I select. And so I'm going to select a date for that hearing. I've already looked at my calendar. I looked at the court's calendar. January 10th is the next truly viable date that the court sees as when this hearing could occur. I'm thinking of 12 o'clock to start that hearing. I wanted to suggest that time to Mr. Reynolds and to Officer Whittle. And I will point out to you, Mr. Reynolds, that one of the issues, if I had viewed this as there's absolutely no chance that the court could come a different angle based on any possible argument made by counsel, then I might have ruled differently on this motion to continue. I am at least paused by the idea of how the animal came into the custody of the police department and then was ultimately at large as a result of being in the custody of the police department. It's not the same circumstance as if the animal was released by the defendant or allowed to run loose by the defendant or escape the defendant's own personal areas. And so I would anticipate that I would want evidence surrounding that to be part of the hearing. I know there's documentation, and I know the civil rules under the quasi-judicial rules allow you to simply provide the police reports or even emails from officers. I would expect for there to be some live testimony surrounding that so that there could be some cross-examination as to what happened with respect to taking the animal into custody and then the subsequent evolution of the animal not being in custody. I'm not saying that will decide it one way or the other, but I think it will be important for me to be able to make a decision, because this is not a circumstance where you come in and said the defendant didn't do X, Y, and Z that was ordered on X date, nor is, if I understand that correctly, is there an incident of an aggressive animal incident that precipitated the dog being taken into custody. It was the dog being at large, and then the fearful response that was created during this encounter. So those are issues that I would be wanting to delve into to some extent at that hearing. So I wanted to give you some notice of that so that if you are interested in providing live testimony, it can be any one of individuals that provided that, but I think it should be somebody who has personal knowledge, and I would not object to that person appearing remotely if necessary. But I may have some questions about that and may want to have more evidence provided by the prosecution as to why this set of circumstances justifies the order of forfeiture. So I wanted to give a little bit of background on that. But I'm going to do a written order, and I'm going to want you to stay to get a copy of that written order. And the reason is I want to make it super, super clear that you're not going to have the opportunity to visit Rollo. If the Humane Society somehow decides they want to give you the authority to visit Rollo in some capacity, that's up to them. But my order will reflect that. And it's not I'm not ordering that you get permission. And so you should anticipate that they will continue with that same policy that's already been in effect, that you won't have an opportunity to visit with Rollo, nor will anyone else during the pendency of this action. And that any expenses that are incurred while the dog is in custody, those expenses for impoundment will be your burden. Do you understand that, Ms. Shadow?
Yes, and I already worked 114 hours this last pay period so that I would have the full cost of the previous fees and fines, which I have currently.
I'm not anxious to get our court paid for fines. I'm anxious to make sure that this private entity, the Humane Society of Boulder Valley, is not and they struggle financially. It's a financial burden for them to have your dog there, and you'll be responsible for all of those fees. Okay. So those are the two things that I want to make it clear of. I will also put in that order that I will not. It is highly, highly, highly unlikely that I would grant a continuance of that hearing from January 10th. I can't envision right now any circumstance upon which I would say it's okay to continue this beyond January 10th. And so that means if the lawyer comes in and says, Judge, I'm in the middle of a murder trial and I cannot do this because I have to do a murder trial, then that means that lawyer won't be representing you. And even if you say, I didn't learn that until January 9th, she didn't get back to me and now I want more time, or the lawyer has someone else, or the lawyer says, I want time to do some additional investigation, I will not be granting that. And I'm going to put that in the order that I'm giving this amount of time for you to do whatever investigation and preparation that you need. But if counsel enters, that counsel needs to be prepared to go to hearing on January 10th, and the court will not look favorably on a request to continue at that time.
And just for a point of clarification, Your Honor, I know that Humane Society will be interested to know what happened today. Would you be able to put in your order as well that the dog is to remain impounded until at least January 10th to give them clarity as to what the situation is to do with the dog?
Yes, and in fact, I'm in my order. I'm going to articulate under section 6128 that I found that an interim impound is appropriate, and that there's probable cause to believe that following a hearing, forfeiture will be justified, and that there's probable cause to believe that the animal constitutes an immediate danger to the community or itself. And so I will put that in the order so that they understand that, and that way we're operating under both of those provisions of 6127 and 6128.
Thank you, Your Honor.
All right. I know this is not ideal. It is the most difficult thing that any of us have to do. The prosecutor's office, I'm sure for Officer Whittle and for others involved, and for me personally, this is the most difficult thing that I have to do as a judge, is to address these issues that have to do with the life of an animal. And I know it's extremely painful for the defendant. That goes without saying. So I will do an order. I'll ask for you to remain here. I should have that order out in the next half hour or so, and then we'll give you a copy of that. The reason I want you to remain is if you're going to represent yourself, that's fine. If you're going to hire counsel, they need to see that order to understand that this is not one where they're going to come in or file a motion to continue and have it be granted. It's not going to be.
Yeah, I don't want to have him there any longer than he needs to be, but I can't give up on him. He would never give up on me.
Okay. Yeah, I say this, I do all this with some trepidation that I'm not doing what's best for your dog. But I'm erring on the side of what I think is procedural fairness. That's the most important part of this right now for me, is to make sure that the procedure is fair. Okay, so I appreciate everybody being here today, and I will go work on that order, and then if you'll just stay here in the courtroom, we'll get you a copy of that.
Am I setting that for the 10th?
Setting it for the 10th at noon. Did we check and see that we have the availability to do that at noon on the 10th?
No, you said January 10th at noon?
That's a Wednesday.
Okay, thank you.
Okay. So Greg will also get a setting notice for everybody for that. Okay, I'm going to step out. We can go ahead and go off the record.
Oh, what a nail biter. That was a nail biter. So I watched this a couple times to get it ready, and you pick up more. So the dog had 2 biting instances. The first one was an actual biting instance. The dog bit someone. The dog was not in her possession. It was in her son's care at the time he had the dog. Okay. The second one, the dog was put on this medication, and the vet told them this is going to lower this dog's inhibition completely. So you got to be careful. Well, the dog bit someone on this medication that lowered his inhibition. So, and then it again in the son's possession. So now she got the dog. She took the dog so it wouldn't be killed, and she got it on anti-anxiety meds. She has all the muzzles and the chains and the bondages that the law requires, but she's not a saint. She's just not. There, I'm sure there's problems with that whole family. She talks to dogs apparently. Well, she was driving through Boulder and got arrested, and the dog was in the car, and the police got the dog, and then the police lost the dog, and they had the whole police department out looking for this dog and drones and everything. The dog didn't bite anybody or do anything while the dog was at large. The dog ran from wherever it was released back to her place of work, and her coworker found it. I think that she has to pay all these fines and costs to the Humane Society. I think she can sue and get those costs back. I just think, I think the dog is doing better now. The dog didn't bite anybody. I think the medication she has on is working. I think that she's being responsible. The police let the dog go. It's not her fault. It wasn't the dog's fault. It was their fault. And now she has to go through all this. This dog almost died today because the police let the dog go. So, man, that was a nail biter. I couldn't wait till the end of that. And he did the right thing. He's that nice judge. This is as hard as he gets. Now, I don't know what's going to happen to the dog. Who knows? But I pray to God that she can get a lawyer, because a lawyer will eat them alive and probably get court costs for her and everything. She has a criminal case going forward too. That's what this lawyer is for, because she got arrested because she's not a saint. But okay, that was emotional. That was a roller coaster. Let's end this on something funny. Arizona.
What's your name?
Christian Meister.
Hi, you're charged with criminal trespass, so I'm going to order you not to go back to the incident location and come back to court on February 5th at 9 o'clock, or a warrant will issue for your arrest.
I don't want to come back. I want to just take care of it now.
Oh. Well, you can plead guilty and I'll send you to time serve and 12 months of probation. Don't go back to the incident location. Do you want to do that?
No, I'm not guilty.
All right, good. Then come back February 5th at 9.
Do I get an attorney?
Nope.
And it's cold in here and they don't give me a blanket.
Well, you're getting out,
Help
so
me with that?
you're getting out, so hopefully you'll find someplace warmer
I'm not
outside.
getting out.
Let's go. This way.
Yeah, I had to end it on something funny. That way we could decompress from the dog case. Oh man. I don't know, Jim. People say I talk too much. I don't care though. Guys, thank you so much for coming out today. I have more. I have so much more. I could keep this stream going on for 5 straight hours, but it's almost 2 hours. So I'm gonna cut it off here and get my next cases ready to start 2024 with a bang. I hope you guys celebrated responsibly last night and no one's in jail. But if you are, then when you get out, you can watch what happens. Thanks, guys. Thanks for coming out. See ya.